Hi, everyone. Thank you for joining us today. We're going to be talking about the differences between revocable and irrevocable trusts. My name is Courtney, and you're joined by Jay Sherrill, the managing attorney of Sherrill Law PC. So you can utilize the chat function on your screen. If you have any questions as we go through, you can put them in there and we will address them all in the Q&A portion towards the end. Just as a reminder, you can see us, but we can't hear or see you, so you don't have to worry about any background noise or anything like that. This presentation is for legal information, not legal advice. So just keep that in mind as well. We're going to be going through this topic and addressing all the common questions that we find associated with revocable trusts and irrevocable trusts, and then we'll address your questions towards the end, so stay tuned for that. Without further ado, here's Jay to discuss.
Hi, welcome everybody. Thanks so much for joining us. And what we are going to talk about today is the difference between revocable trusts and irrevocable trusts. And I don't want to spoil it, but I'll give you a hint. There's not really all that much difference. And so we will go through the differences. They are different objectives that we can accomplish with each one, but the tools themselves may not be as different as you think. And so you might be surprised to learn some of the material we'll learn later on. And the reason we're putting this together is just so important because it's really important that you know this information, because it's common myths that people have that can lead a lot of people astray into actions that they probably wouldn't have taken if they knew all the information, or sometimes not taking action because they thought that things were different than they really were. So just a little bit of disclaimer for our insurance company so they'll be nice and happy and won't give us a hard time. We're going to talk about today is just educational purposes only. Naturally, we don't represent any of you, though I would love the opportunity to help anybody who needs help in the future. What we're going to talk about today is legal information, so please do not just run out and start doing things based off our webinar today. So this is going to be for you, and you are going to find this to be a productive time together if you want and need to know your options. So if you're thinking about how a trust might fit into your estate plan or your life or your legacy, this will be good information for you to kind of help formulate that and educate you a little bit. So that way, if you do decide to do that as part of your plan, that you're an educated consumer of legal services. This is also for you if you've never put anything together before, because we'll talk about some basics. And it might be a good opportunity after today's webinar as well, if you haven't looked at your estate plan, to go back and look at some of the concepts we're talking about. But most importantly, what we help people do is organize their estates. A lot of what we'll talk about today are really strategies to protect assets, to make things easier on our beneficiaries, to keep unnecessary money out of the hands of the government, whether it's for long-term care or for taxes. And so that way our intended beneficiaries, often our closest loved ones, our family, can inherit our money that we've worked so hard for. And we help people do that. And helping you become educated about your options gives you the framework to be able to know what your thoughts are on a lot of what we are going to talk about today. Now, what we'll discover is going to be, first, we'll start with just a basic of what is estate planning. And so when we talk about that, we'll talk about some common tools. We'll talk briefly about some healthcare directives, and we'll spend a little bit of time talking about the difference between wills and trusts to start. And then we'll talk about probate avoidance and what probate is and why you might want to avoid that. And then lastly, we'll talk about the differences between revocable versus irrevocable trusts. I saved it for last because you're going to have that buildup of information so we can have an educated conversation about it. Otherwise, if we dive into the deep end without having first taken those first few steps, then we will be drowning. So imagine we could wave a magic wand and our hard-earned assets were protected, that you're able to leave behind a legacy that you desire, right? It's not the same for everybody. It's the one that you desire. And you are able to take control over your estate, keep the state out of your business, choose your beneficiaries. That's what you do with estate planning. Now, there's all different iterations of it, but ultimately, that's what you're doing with estate planning. Now, before we dive in, a little bit about myself. My name is Jay Sherrill. I am the owner, managing attorney of Sherrill Law PC. We are an estate planning and elder law practice here in Suffolk County. We help clients like you deal with these issues, flesh out their desires, flesh out their plans, and ultimately help them implement an estate plan and maintain estate plans that accomplish what they're looking for. This is my wife and I, and it's just a little bit about why we do what we do. I realized very early on that in my career that these life moments are what really are the ability to have lasting effects. Like this was a wedding. This was my wife and I when we were little kids, and this is a wedding where the funds, I know I've spoken to the family, were paid for through gifts, right, through estates, right, through inheritances that were received from their family, and it creates the ability here. Now, flash forward to our wedding and to these beautiful children that allows for life to happen, right? So this money is really just a means to an end, right? And the end is life. And so it's not just about the dollars, right? It's about the weddings, it's about the births, it's about the investments that can be made, the businesses that can be started, the peace of mind and security that you can leave your loved ones. And I'm so passionate about what we do because the laws are so complicated, and when people don't know them, they lose out. They lose out because they had opportunities to protect their assets. Now, if a person doesn't want to protect their assets, that's not on me to tell them that they're wrong. But if they want to protect their assets, I never want to see them lose out on an opportunity simply because they either didn't know or they misunderstood it. And my favorite part of what we do, which I can't see on the screen today because I can't see your faces, is seeing people's faces, seeing their worry turn to relief. Now, let's talk about how you can create an estate that addresses your particular needs. First, we're going to dive into estate planning. We'll talk about the revocable and irrevocable trusts and probate avoidance. So what, again, more specifically, what is estate planning? Well, number one, a piece that many people overlook is we're addressing our future medical needs, planning for incapacity, and planning for long-term care, planning to protect assets. And this may include planning for Medicaid, and many of you may know that. Now, the common tools that we see be part of an estate plan are our power of attorney, healthcare proxy, HIPAA, living will. Now, these are what I would call advanced directives. And what advanced directives do is they basically allow you to avoid the need for a guardianship proceeding. And if we're talking about protecting assets, that is a costly one. If someone needs a guardianship proceeding because they didn't have adequate advanced directives, it is a very time-consuming and costly proceeding that really continues for the rest of the person's life. So having that stuff in place is your number one easiest step towards protecting your assets, protecting yourself and protecting your assets, keeping the state out of these important decisions, right? And keeping the family harmony to the extent that we can, status quo. And so that then turns to wills and trusts. And what wills and trusts do are really taking care of assets when we pass away. I think the most common that people think of is a will. And it says who gets your money when you pass away and on what terms and who's in charge of it. Now, the person who's in charge of it is called an executor. And the people that get your money when you pass away, according to your will, are your beneficiaries. Now, you can make what's called outright distributions. You can make distributions in trust. People do things like that to protect money if a beneficiary is disabled, for example, or if a person is concerned if that child, for example, they're leaving money to gets divorced and they want to keep it in the family for their grandchildren. You have a lot of different options on how you give money. Either way, that all gets done in a will. Now, it can also be done in a trust. So what's the difference? The difference is in how trusts work versus wills. Okay? Now, the way that they work is that wills need to be probated. Now, what is probate? Probate is the process where a will is proven to be a valid will. You might be saying, what does that even mean? Why does that have to happen? I'm leaving everything to my kids. It's super simple, right? Yes, it sounds simple. The thing is, these issues only ever come up is after you pass away. So there is a process before the court to validate a will. There are specific requirements to the validity of a will. And there are specific people who are interested, right, and able to be heard about that will's validity. And notably, you're not alive to say, hey, yeah, that's my will. No need to go through any of this. I'm verifying that for you right now. It's not something that we have in New York, although some states are starting to gain some steam around this idea of what they're calling pre-death probate, which might be a nice thing. But either way, it's not available to us here. So probate is that process, that court action of proving that the will was valid and notifying all the people who would be interested in that will. That might be people that are named in the document or people who are disinherited by the document. They have a right to be heard as to whether it's a valid will. All of that happens regardless of whether everybody's in agreement or not. If everybody's in agreement, it can be expedited a little bit, in that everybody can sign off on what are called like a waiver. It's an agreement that the will is valid and everything then before the court is done without a need for court appearances. But we're still dependent on the court to go through the process of this legal action. So, for example, as it stands right now, you're looking at about anywhere between a 3 to 7 month delay from the time that you file the application for probate along with the will to the point where letters testamentary are issued. That's the end of the proceeding, like where the will is granted probate. And that's in uncontested matters. Now you can imagine a contested matter, it will take longer because now there's hearing dates and there's a exchange of documents back and forth and depositions and testimony and all these things, right? At the end of that proceeding, then what's called letters testamentary are issued, which is what allows the executor that you've named to be in charge of the estate to actually start acting as the executor. All they could have done up until this point was probate the will. And really what that means is during that time frame, nobody can do anything on behalf of the estate. And we saw this come up a lot during the pandemic. The real estate market went crazy outside of New York City, right? Everybody wanted to get outside of New York City. Early on in the pandemic, people were dying. Now, people that were dealing with the estates that had wills had to go file wills for probate, and no one could take charge of the real estate to sell it or rent it until the court granted probate. Now, the court closed down indefinitely during that time period, and basically no one was able to get letters, meaning that nobody could do anything with that real estate. All the while, there was taxes owed, upkeep, maintenance. They had to keep the lawn mowed. Somebody had to come up with the money to deal with all this stuff and front that money for the estate. Now, meanwhile, people with trusts didn't have to go through that waiting process. There is no probate with a trust. There's no need to go to court to get them working. They work automatically, okay, from the time that you create them. They're called living trusts for that reason. They're alive, even though they're not really alive. They're pieces of paper and ink. I just thought of something. A live trust might be a cool graphic one time for like an advertisement for a trust, like a living trust. Anyway, so they're alive, right? They are able to be used while you're alive for different purposes. And when you pass away, there's no need to go through a court process to prove them. And there's no need to go through a court process to maintain control over the assets that are inside of them. That's a really nice benefit when you consider things like what I just described to you, which is the upkeep of difficult assets like real estate, and also lost opportunity costs that might come from a delay. And we don't know what they might be. I could have never foreseen that happening. Like I think any of us had never foreseen a once in a decade, as a once in a century type pandemic with the things that we went through. So let's talk a little bit about trust planning then, because there's a lot of different trusts that we then need to talk about in terms of different objectives. So just to put everything back so far of what we've talked about, I had to give you some run-up about basic estate planning and what that is about, and probate, so you can understand the value of trusts, okay, or where they might fit into your estate planning objectives. But now once we do that, we have to start to think about what type of trust do we need. Now, the first thing you'll want to do before you even begin to start thinking about saying to an attorney or anybody's, what are your goals? Start to think about it and say, what do we want to accomplish? And I'm going to tell you some of the goals that you might accomplish as we go through today's webinar. And that's the point. So that way you can consider them. And rather than calling up an attorney and saying, I want an irrevocable trust, then you truly understand where that might fit into your plan. And maybe you do want that, but maybe you don't. Because if you call up an attorney and ask for an irrevocable trust, you know what they're going to give you, an irrevocable trust, right? But maybe that's not exactly what you needed. If you will call up and ask about estate planning, now the person's going to be helping you plan out the estate. It's the difference between asking for a door and a house, right? You're asking for much more when you're talking about estate planning than you are when you're asking for just one component of it. You want to think about your individual family needs. Do you have people in your family that are disabled, like I was mentioning, have creditor issues, gambling issues, that have maybe less than stable marriages that you're not exactly happy with, a high net worth, subject to, I would call, lawsuit magnets like doctors or police officers, where you might want to protect assets from them. We'll want to make sure we've reviewed and properly looked at and inventoried all of your assets, so we're considering the whole picture. For example, in a probate avoidance plan, it's not enough to just take care of one asset. You got to take care of them all. And there's a specific identified plan based off of your asset inventory on what needs to happen to accomplish that. And then think about your tolerance for protecting assets. Are you someone that wants to protect assets from the nursing home? Now, nobody has ever said to me, I want to go to a nursing home. In fact, I love some of the comments that we get on our webinar advertisements or invitations. We see people go, I would never go to a nursing home. I would never. They're the worst. I would sooner die. Right? I think everybody feels the same way. Nobody wants to go there. But the reality of the situation is a certain percentage of people do need that. And it's not because they want to be there. It's because they need to be there. Their care cannot be safely met at home for whatever reason. Okay. And so if we do find ourselves in that position, a trust can be like an insurance plan, in the sense that, really all estate planning is an insurance, right? It's that you want to have it and not need it, and have over planned than to need it and not have it and have under planned. So if you're thinking about protecting assets from the nursing home and saying, I never want to be in a nursing home, but if I did need to be there, well, then I don't want it to be worse. And now my house is being taken, my assets are being taken, and I can't leave my hard-earned assets to my family. So think about that. Now, let's talk about revocable living trusts. Now, what is the main goal of a revocable living trust? The main goal of a revocable living trust is to avoid probate. Okay? That's really all that it will do. It'll avoid probate. It won't provide any sort of asset protection. It won't protect assets from the nursing home. For the most part, there's some limited circumstances where it can, but beyond the topic of today's webinar. It also will keep things private. Okay, so by avoiding probate, we maintain control over the trust assets and don't run into those issues that I was telling you about before, with the court being closed and people having to wait for months to be able to get access to assets. And this, by having a trust in place, you maintain control. Because it's not filed anywhere, it's not put in a court action anywhere, it's not a public document, it's not a public proceeding. I think a lot of people that put together trusts don't want their assets to be public. And I'm not saying we're being super secretive here either. We're just not going down a route where we are forced to file a document with everybody's names and addresses and assets and net worth in there, and then file an inventory later on down the road that also has total assets and how they were held. And then if there's a dispute, that's all in the public eye. And it's something that people consider. Now, one question that people have about these revocable living trusts is they say, well, wait a second, if I do that, then I'm not in control of my asset. Now, let's talk about who is in control of a trust. Who's in control of a trust is called the trustee. It's easy to remember, right? Trustee. The person who's in control of a trust, whether revocable or irrevocable, is called a trustee. Now, it's most common with a revocable living trust that the person that created the trust, often called a grantor, is the person that's in control. It also means that most commonly the beneficiary, the person who's entitled to enjoy and use the money that's inside of the trust, enjoy and use the assets that are inside the trust, is called a beneficiary. It's most common that the beneficiary, as long as the person who created the trust is alive, is the person who created the trust. So, in the legal terms, we're saying that with a revocable trust, the grantor is often the trustee and the beneficiary. And why is that? Because you're not looking to lose control and access over your money or your assets. You're just trying to consolidate them in a vehicle that will allow them to pass court-free, right, without having to go through probate. And if I had to do an illustration, like an analogy, the difference really becomes between a will and a trust is if I was a pirate, right, going on a treasure hunt, the will would be the treasure map. It's mapping out what's got to happen, but then the executor, the person in charge of it, needs to follow all those steps to get to the treasure chest, which is all the assets, and then needs to go about giving out those assets to the rest of the people on the ship, right? Or the beneficiaries. But the trust instead is like, forget the map. We don't need to go through, the forest, down to the river, and sail across the seven seas. No, we have the chest. The trust is the chest. It's right there. You put all the gold, all the assets into the box, and the box can just be handed over by the very terms of the trust automatically when you pass away. Now, another common myth that we hear about trusts is that they can't be changed. Now, that's one of the major benefits of a revocable trust is that it can be revoked and it can be changed without any complication whatsoever. You don't need to get anybody involved. You don't need to get a court involved at all to do that. You have complete control over that. So it's a nice vehicle because anything you put inside of it consolidates assets, provides avoidance of probate, keeps them private, maintains control upon your incapacity and death, and you have full use and control and enjoyment of them, and you can change and revoke this trust at any time. It's a very nice estate planning tool for many people. Now, let's talk about asset protection before we talk about irrevocable trusts. Because irrevocable trusts are what we use, for the most part, for asset protection. But what might you want to protect your assets from? Well, probate is one of them, right? And we just talked about that before. Probate can be a lost opportunity cost and just a delay that's costly. But beyond that, because we're moving now into the irrevocable trust, we want to be thinking about either long-term care costs or estate taxes. Now, I'm going to spend the majority of our time today talking about long-term care costs. I will briefly tell you about estate taxes. And if this is something that concerns you, call our office. We'll give you some materials about it. Because estate taxes will only affect estates where the assets are approaching, if not more than about $6 million. Okay? If we're on the cusp, we might want to think about it starting at about 4.5 to 5 million, where we might want to start thinking about some of the planning so we can plan ahead for appreciation. But we're not really going to see that be an issue unless the estates are approaching those numbers. So if that's the case, call us, email us. We have so much material on that. So we're not going to spend time today talking about some of those more complicated estate tax minimization strategies. But the irrevocable trust, in many different combinations of that, is the tool that is used. But it's just that there's a lot that goes into that. One, we could do a whole webinar. So what I'll spend most of our time talking about today is then long-term care costs. Now, what is long-term care? Long-term care is planning for the need for home care or nursing home in the future, right? It's assisted living, it's home care, nurses, it's it's assistance at home with activities of daily living, it's skilled nursing facilities, it's rehab. Medicare does not pay for this, okay? And commercial private health insurance does not pay for it either. You either need to pay for it out of pocket, you need to have long-term care insurance, either a regular traditional policy or a life insurance policy with a long-term care rider, or you need to have Medicaid. And what Medicaid is a program that comes from the state of New York and the federal government together. They've teamed up to provide long-term care coverage to needy people. And our goal with asset protection is to not let the nursing home make us needy and then need the program anyway, but to work within the confines of the Medicaid rules to protect assets before we become needy. Okay? And when we do that, we want to focus on minimizing our income taxes. That'll happen down the road. So the income taxes usually come up upon your death for your heirs. So any of the planning that we do, with trust is going to want to minimize the income taxes that'll be due for your kids down the road or for your beneficiaries down the road. So that way they're getting more in their pocket and less in Uncle Sam's. So the tool that we most often use is called an irrevocable trust. Now, like the tax planning trust, irrevocable trust is something we use for both. So this will apply to both. And we'll talk more about a specific terms of a specific trust that we'll use for Medicaid purposes. But let's just talk about irrevocable trusts to begin with. Now, they also avoid probate, okay? Because anything inside of a trust, whether it's irrevocable or revocable, will avoid probate. It'll also be private because that's just how all trusts work, okay? But often, though, where we have an irrevocable trust, often the grantor will not be the trustee or they will not be the sole trustee. And that's because we're trying to create more provisions in there that can't be changed. And this can be for reasons like, I want it to go to my children, but not to their spouses if they were to pass away. Or I want it to go to a trust for my son who's a doctor, and I don't want him to get sued. Or it can go to a Medicaid trust, which we'll talk about in the next slide. But most times the grantor is not the only trustee. And in fact, if you created a living irrevocable trust for the purposes of Medicaid, you couldn't be the trustee. You'd be giving up control over your assets. But we'll talk about why that's not such a bad thing or doesn't quite mean what you think it means. So that's the big teaser that I left you with earlier. Irrevocable doesn't mean what you think it means. Okay? If it's properly prepared, if the terms of the trust are properly prepared, then there's ways that we can revoke the trust, ways that we can maintain control over the trust. Okay, now I'll tell you about some of those terms. If you have a trust already, this is something that you're going to want to take a look at and make sure it was prepared that way. And the reason I say that is because it's not a requirement to make an irrevocable trust that you have this foresight to plan this into it. Many trusts do come around our office where other people have prepared that don't have this. And that's a problem when the person wants to revoke it. So let's talk about mainly the specifics of a Medicaid asset protection trust. Okay. This is most commonly used to put assets inside, most commonly a house, but certainly other assets as well, to protect them from Medicaid recovery and allow the people to get Medicaid for the nursing home and home care in the future. Now, the key with this, though, is that it needs to be done 5 years before needing a nursing home. Now, I don't have a crystal ball, but if you or your parents or siblings are thinking about this planning, think of it like insurance. Think of it like I should be planning as early as possible, so that way 5 years can run and the assets that I've put inside of the trust will be fully protected from the nursing home. And the assets inside of the trust will also be avoiding probate, be protected from estate recovery or protect any clawbacks that the state can do. Now, when we do a trust like this, we will reserve a person the right to live in their house because that's what's most important for them. We just want to protect the equity, but we also want to make sure they have a safe place to live and that they can never be evicted and they can never be kicked out or charged rent. Now, protecting the house, when we were talking about control, the house cannot be sold if it's properly prepared, right? In this type of trust, the house cannot be sold without the beneficiary knowing. So if I transfer my house to a trust to protect it from Medicaid and I name my daughter as trustee, then she would not be able to sell the house without my okay because I reserve the right to live in it. It'll minimize income taxes and protect your property tax benefits. So what I call that is tax neutral, right? It's not going to change your taxes for the better. It's not going to make your taxes worse. It's going to make them stay the same, which is a really important thing because what this is about, the step up here, is income taxes upon the sale of your house after you leave it to your children. If you give it to them, for example, bypassing the need for this trust idea or probate avoidance, because now you no longer own your home, you don't have a right to live in your house anymore. It could be foreclosed on. They could kick you out, charge you rent. But also, let's say everybody's happy and never going to do any of that stuff to you. When they sell it down the road, they're going to have to pay more income taxes. They will lose what's called a step up, which means any gain during your lifetime would have been erased, and we want to preserve that. Now, a Medicaid Asset Protection Trust is an irrevocable trust, but it's not really irrevocable. All that irrevocable means in this context is that you, the person that created it, can't revoke it on your own. Okay? But it still can be revoked. It can be revoked by an order of the court. Now, we don't want that, right? But it could also be revoked with consent of the trustees, the people that are in control of the trust, and the beneficiaries. So let's talk about a common plan that we see. Husband and wife create a Medicaid Asset Protection Trust, put house and some other assets inside of it, hoping to get past the 5-year clock. 2 years in, one of them needs a nursing home. That's a problem. We got to get it back. Okay, what do? We reach out to trustee, whose daughter, and beneficiary, whose daughter. And we say, we want to revoke the trust. We need your signature. Daughter says, okay. She signs as trustee and as beneficiary. Creators, the mom and dad, they also sign. The trust is revoked. It's put back in their name. All is happy. Okay? What happens if daughter says, hey, hit the bricks. This is my future inheritance. I'm not revoking that. I don't want to take it back out. The Medicaid is just going to take it, right? Okay, what do? We change the trustee. We change the beneficiary. Now, isn't that changing an irrevocable trust? No. If it's properly prepared, we're creating a right for you to change the trustee and change the beneficiary from day one. We're not changing the trust. You're just going to exercise your right to fire that trustee, fire that beneficiary that can't or won't sign. You're going to get rid of them. You appoint whoever you want. So if those people are the people that have to consent to the revocation, or those trustees are the people that are in control, but you ultimately have the unqualified right to replace and remove and replace those trustees and those beneficiaries at any time, you have the indirect control to control who controls. Does that make sense? And by doing that, you have control. Like if I had a security system that said, for nuclear weapons, for example, there's got to be 2 key holders at any given time to be able to fire those weapons. But the person who can order the weapons also has the ability to choose at any given time who the key holders are. When they go to key holder 1 and say, yeah, fire the nuclear weapons, and they go, no. And they go, all right, great, you're fired. All right, put the next guy in who will say yes to me. That's the same thing that's happening with a properly prepared Medicaid Asset Protection Trust. And by doing it, then what's the whole goal? Is you want to put assets into it 5 years before needing a nursing home, because you don't know when you're going to need it or if you'll ever need it. So you're doing it for insurance purposes, right? You're doing it so that way you're basically insured. It's not really insurance, but insured against that care if needed, but that you maintain some degree of flexibility and control over your estate plan. And so let's just sum up what we talked about, because we talked about a lot. And then I'm going to open it up for Q&A to help with anybody's particular questions that I can help with. Let's sum up revocable versus irrevocable trusts. Now, both of them avoid probate. Okay, we're clear on that. Both provide privacy because they're both happening outside of the court. Now, on its face, the revocable trust provides accessibility and flexibility. Okay, and on its face, the irrevocable trust is providing asset protection. But realistically, if the trust was properly prepared, the irrevocable trust, like the illustration of the Medicaid trust I just gave you, is prepared properly, we're still going to get accessibility and flexibility. It's just going to be through a roundabout way. Now, the revocable trust is easily revocable. Now, the irrevocable trust is on its face irrevocable, but we know what that means now. It means that it can be revoked by the beneficiaries and by the trustees and by the grantors, the people that created it. So it can be revoked. It's just not revocable by the direction of only the person that created it. And lastly, we in a revocable trust maintain control and management over it. And in the irrevocable trust, we delegate that management over the assets to someone else. Now, don't forget, we get to replace who that someone else is at any given time, and we can remove them, but ultimately we are delegating the access over and the maintenance over and the management over. We can't fire that person and then assume control ourselves. We basically just have control over the controllers. All right, so imagine you can wave your magic wand again and your estate plan was up to date. You left the legacy you desire and you could choose your estate beneficiaries, protect your hard-earned assets. Again, this is what estate planning is. And what you need to do before doing anything else is think about your values and your legacy. If you have an estate plan, then review it and see if that matches what you need. If you need help doing that, reach out to an estate planning attorney. If you don't have an estate plan, then you need to get one. Everybody needs one, because if you don't have a plan, the state has one for you. We talked about our common estate planning tools and how to protect your loved ones, and how to avoid probate, what the difference between the two trusts are. And if there's anything that I hope you get from this before we dive into the Q&A, is that there is no one-size-fits-all approach to estate planning. Estate planning is so unique to the individual. It's so unique to just you. Now, the trusts and the tools and things we talked about might be things that many people use, but ultimately, right, this is tailored to your specific needs, your specific goals, your specific objectives. And what we can do to help you flesh that out after you've had that initial conversation is have an estate plan discovery session. It's for you if you have a family or have loved ones that you want to be able to protect your assets for and make sure that you're prepared for your future. And what we'll do in that meeting is a virtual 20-minute meeting with a representative from our office where we'll discuss your goals, provide some more resources. We have a wealth of information for you about different topics that might answer some of the questions that you have in more greater detail than I can do today. And we will help discuss your desired legacy. So help have that conversation, essentially, that I was mentioning with you. And if that's something that we can do to help you, we'll discuss how we can help implement that for you. And at the end of that time, you'll have talked through your goals and your wishes. You'll know any gaps or action items you need to do. And if we need a deeper dive into anything, we can schedule a strategy session. Now, the best part of this discovery call is it's complimentary for the attendees of this webinar. So go ahead and you could go ahead and call us to schedule that. We're going to go to Q&A, but I'll put our contact information up so that you can see that. So I'm just going to bypass that slide. So you can call us or reach out to us by email at your convenience to schedule that call. Now let's go ahead and go to the Q&A.
Okay, perfect. So we're going to start off with the first question is about shelter credit trusts. Can we touch briefly on what those are?
Credit shelter trusts are a tool that are pretty much unique to New York State or similar states, but mostly New York State estate tax planning. Now, and this comes from a basic understanding of tax law. I'm going to try to do it as best I can in easy language. All right. In New York State, each spouse has a just over $6 million exemption. All right, this means that they can leave up to $6 million tax-free before the estate tax kicks in. Okay, so I have $5 million. I leave it all to my spouse, and then she has everything and passes away. There's no estate tax due. Okay, but what happens if the assets are $8 million? Now we're over the $6 million exemption. In New York, there's no sharing of the exemptions. So when one spouse dies, if they don't use their exemption, they lose their exemption. And the surviving spouse only has their own exemption. So in New York, that would mean when one spouse dies, and let's say that everything was in joint name, make it really simple. All accounts, all assets were in joint name. So husband dies, and everything goes to the surviving spouse. And let's say their assets were total $8 million. Spouse now has $8 million. When spouse one died, everything, an unlimited amount of money, can go to the surviving spouse tax-free. It's called a spousal deduction. But because of that, the estate tax exemption belonging to that first spouse to die is not used. It's not needed. There's nothing to shield from the estate tax because it went to the surviving spouse. They pass away, that $6 million exemption is gone. Now, surviving spouse is sitting with $8 million in their name and $6 million of an exemption. Now, that sounds, how would we calculate the tax? We don't just go and say 8 million minus 6 million, 2 million is taxable. No. New York is not that kind. No, what New York does is they say when you go over the exemption, then you lose the exemption. And so all 8 million in that example would be taxable at about 16%. Okay, so we're talking about almost 20% right there. It's a large sum of money that there's a tax bill for. Now, that's all to set up the stage for what is the question, right? Which was, what is a credit shelter trust? A credit shelter trust is a estate planning tool that is used to preserve the estate tax exemption that first spouse died with and wasted. So go back to our example, husband dies first. Instead of having left everything in joint name, we separated the assets. So husband had 4 million and spouse had 4 million instead of having joint name 8 million. Now husband dies, and instead of leaving the money to the surviving spouse, we leave it to a credit shelter trust for her benefit. Make her the beneficiary of the trust. We could even potentially make her the trustee of the trust. We do that. Now we used $4 million of first spouse to die's exemption. Now he had 2 million left, but we used 4 million of it. Now, surviving spouse, what does she own? She has $4 million and a trust for $4 million. She doesn't have 8 million. She has $4 million and a trust for $4 million. When she dies, the only part that'll be included in her taxable estate is the 4 million that's in her name, not the 4 million that's in a trust. So now she has an exemption of 6 million and only taxable assets of 4 million, meaning that she's well below the exemption and there would be no tax due. So with the same family, by using a credit shelter trust, we just reduced their estate tax bill, which would have been upwards of $1 million, down to zero. All right, that's what a credit shelter trust is. Oh, Courtney, I can't hear you.
Oops, sorry about that. The next question is, what are the tax benefits of both a revocable and irrevocable trust?
So let's talk about the ones I spoke about today to keep it simple, because there's a lot of different pieces. So those two trusts, there's really no tax benefits because they're both prepared as like the Medicaid trust we were talking about and a revocable trust are both prepared as what we call tax neutral, meaning that we want other benefits out of them, like probate avoidance, or we want benefits like the Medicaid protection, but we at the same time don't want to negatively affect our tax situation. Does that make sense? So, for example, many people come to us and say, like, oh, yeah, I want to just give the house to the kids. Besides all the other problems with that, let's say that nothing bad happened. Like, none of the kids died. They didn't have a falling out with any of the kids, or the kids didn't kick them out. Forget about all that stuff. Let's say everything was copacetic. Everybody was happy. that would have a negative tax impact potentially on the family if there was gain, which happens to a lot of people with their houses, which is a wonderful thing. I met with a client yesterday who had bought a house in Southampton. It was like in the 80s and they built it from a little cottage for $60,000, and now the house is worth 1.75 million. All that gain is taxable. Okay, all that gain is taxable, and so what happens is that is something that we want to pass to our kids efficiently, so they get what's called a step up in basis. And when I say kids, it could be any beneficiary. So they get what's called a step up, and what the step up is an erasure of that gain. So what we do with those revocable trusts and the irrevocable trust for Medicaid purposes is want to preserve that right. So that way we don't just give it out to the kids like we said with the deed before, and that does present a problem. And now they have, great, you avoided probate, great, you avoided Medicaid, but now you just incurred a $500,000 tax bill. So that's what we're trying to be mindful of when we draft these trusts. Now, many different trusts can be drafted for estate tax minimization, and then we also there need to consider the income tax consequences of doing it, so we can figure out the net savings. But that's the topic of another webinar that we can certainly schedule, or we can give to you the content we have.
Okay, perfect. The next question is, can the grantor of an irrevocable trust maintain the management of the assets in the trust?
Yes and no. For some types of trusts, yes. Not for the Medicaid Asset Protection Trust. Okay, and the reason is it's not a rule of trusts, because you can have irrevocable trusts that have a person that is a grantor be the trustee. It's just that for Medicaid purposes, the Medicaid rules will count any assets in a trust like that as an available asset for Medicaid purposes, meaning assets that the nursing home and the state are going to go after, right? Or would just completely disqualify the applicant for it. So even though we could do that with an irrevocable trust, if we're using that irrevocable trust for Medicaid purposes, doing that will negate any Medicaid planning benefits. So then it would be silly to have even done that type of trust with the person as a trustee.
Okay, perfect. The next question is, if you have a Medicaid irrevocable trust, does that mean that you get Medicaid to cover the nursing home costs?
Maybe. And the maybe is, well, number one, it had to have been done 5 years ago. Okay, let's say we're applying today for nursing home, right? If you have the Medicaid trust and you have assets inside the Medicaid trust, it means that it will have had to have been done and gifted to the trust created and the assets put in the trust 5 years ago. Okay, more than 5 years ago, like 5 years and a day and behind. Otherwise, the gifts to the trust will make the person ineligible for Medicaid. This is why I was saying it's so important to plan for this before you need it. If you want to use a Medicaid asset protection trust, you need to plan in advance. All right, that's number one thing that could make it a maybe, right? The second thing is the assets in the trust have to be used the right way or managed the right way. The trustee cannot commingle, like mix up all the assets or take money out of the trust and pay your bills, take your money and put the bills in there. That will cause Medicaid to look through and ignore the trust and count the assets in there. So the administration of the trust needs to be followed the right way. The last thing is the trust needs to be drafted the right way. And so I unfortunately have had to have difficult conversations with clients before where they believe they have the proper trust in place, but they don't. So if it's a properly prepared trust, it was done early enough and it was used properly, yes, but right, there's other things going on. Like what if you only put your house in, but you didn't put a brokerage account in, and that brokerage account was $300,000. We have a problem with that brokerage account. And so we have to plan around that now. So it really comes down to the conversations that you're having as a family, the planning you're doing with your estate planners, and making sure everything is up and up.
Okay, perfect. The next question is, Their mother has an irrevocable trust, which was done in January 2023 for her home, but it appears she may need home care. Will Medicaid still have access to her home?
So right now, there is no look back period for home care Medicaid. Okay. So what a plan from Medicaid perspective or healthcare perspective for mom might be is house in the irrevocable trust, right? Keep it there and try to get home care Medicaid and get that. I say you can get home care Medicaid, assuming that she has no other assets. Uh, but get that care and try to make that work for 5 years, basically. She can't go into a nursing home until January of 2028, okay, or one day after that. Otherwise, the plan that you set up is going to fail. Now, I'm not saying you have done it wrong. We do this a lot with people where they're going on community Medicaid, and we're hopeful that we'll get past the 5 years. And a lot of times the conversation is, I'd rather do it now and hope to get past the 5 years. And if we don't, then undo it rather than not do it and then actually get past the 5 years and wish we would have had it done it. So I don't necessarily think you did a bad thing by doing what you've done. But yes, you can still get community Medicaid. There is no look back period. If you have other assets that are outside that trust, you may want to consider putting some of them in the trust to protect them from community Medicaid. Okay, because there's other things beyond just this component of it that go into someone's eligibility. But lastly, I just want to put on everybody's radar, there will be a look back period. We're anticipating of about 2.5 years for community Medicaid coming down the pike, with the exact implementation date or effective date of that still unknown. So for those that are listening that are planning for community Medicaid, potentially, you got to get ahead of that and also do that 2.5 years before needing care. Okay. Because we're in some weird kind of limbo where the law has been passed, but the state hasn't rolled it out yet, and we don't exactly know when yet.
And for anyone that's interested in the look back period on that community Medicaid, we have a ton of resources on that. So you can always email me or schedule a call, and I can accumulate the information that would work best for you for that look back period in nursing home Medicaid. And we also have community Medicaid as well. The next question is, does the credit sheltered trust get set up before the death of the first, I'm assuming, spouse?
So usually no. Usually a credit shelter trust will appear in either a person's will as one of the what we call testamentary trusts, like as a standby trust that may be needed, or it'll appear in a person's revocable trust or their living trust that they've created. And these type of trusts can be like, I mean, trust in general. I don't have it with me; it's in the conference room. But it's like those dolls where you take the top off, and there's another little doll inside, and another little doll. So no, it's not something that's created now. It would be you. Sorry, you need to create the terms of it, but like legally speaking, it doesn't become an effective trust until the first spouse passes away. And most of the time, we put in a clause in the trust or the will that allows the executor to elect whether it's necessary or not. So, like to turn it on or turn it off. So it's kind of sitting there as available. It's drafted. It's ready. It's there to be used, but it's not legally like fundable with assets until the first spouse passes away, and it's necessary.
Okay. The next question is, their father left an inherited IRA and a traditional IRA, which they understand needs to be used in 10 years. They're asking, what do you suggest I do tax-wise? Is gifting some of that money to children as a gift a good idea? How can I gift or protect inherited money?
Okay, so specifically for the IRA, you're not forced to use it all in 10 years. You're forced to withdraw all of it in 10 years. Okay, you're not forced to spend all that money. What you are forced to do is take out all the money out of the IRA in 10 years. It's called a required distribution, and it's called a required minimum distribution because you could take out extra. Okay, you don't have to take out just it all in 1/10. You could take out 20% this year if you wanted to. Okay. The reason for this is because IRAs were funded with pre-tax dollars during your parents or whoever was the original owner during their lifetime. and they've never paid tax on that money. And not only that, that money then, I hope, grew in the IRA. So maybe they put in $5,000, and that $5,000 actually grew to $50,000, and then times that by however many years they were doing that for. That all that money grew tax-free. Now, when you have an IRA, people hold it and they let that grow tax-free because that's really nice, right? But the IRS wants to start getting paid, and so they force people when they hit 72 and a half to start taking money out in a called an RMD. And if they haven't taken all that money out by the time they die, or whether they were required to take out money or not, when a person dies and they give that IRA to their beneficiaries, they're required to take it out within 10 years. So the IRS is trying to get paid, right? That's what it is. The IRS and the taxing authorities are trying to get paid. So they take out that money. You're not forced to spend it all, okay? There are ways. So what happens with that money then? You could take it out. We'll call. You could sell the assets, like if it's in stocks and bonds, and take out the money, or you could actually take out the securities if you have money to pay the taxes on it. What happens is that money or that value becomes on your tax return, okay, and it shows up as taxable income. So minimizing this and having some strategy in this will come down to talking to someone like an estate planner, talking to someone like an accountant to figure what is your projected tax rates going to be over that course of 10 years. And figuring that we may want to take out money now at a lower tax rate if we're going to think we're making more money in the future. If we're making less money in the future than we're making now, and we have a lower tax rate, we want to take out less now and more later. There isn't really anything you can do with it to give it to your children in order to stop that process from happening. Really, the only thing that would happen would be is if you died before you took out all that money, you have beneficiaries on it, it goes to your children, and then it kind of resets the 10-year clock for them. They would then have 10 years to take it out. Okay. That being said, I was dealing with this yesterday with a client. You could take out money out of the IRA and you can give it to charity, and that can give you a tax deduction. So there's a lot of planning that can go into it, but ultimately there's no way around that having to take it out within 10 years. But I just wanted to clear up that for you. You don't have to spend it. You just have to take it out of the IRA and pay the tax on it.
Okay, perfect. The next question is, if you still have a mortgage, do you need estate planning?
Yes. Yes, you need an estate plan. Beyond what we were just talking today, I mean, even just a basic estate plan is a will, which says what happens with your assets when you pass away, a power of attorney, a healthcare proxy, and a living will to keep you protected and keep your personal healthcare and financial matters out of the court system for the rest of your life. Like, that's so important that anybody over the age of 18, right, needs a basic estate plan. So absolutely. Now, when we were talking about trusts, yes, you own a piece of real estate. The way this works is you own that real estate. You have a mortgage on it. And what is a mortgage, really? A mortgage isn't a debt. And a mortgage doesn't mean the bank owns your real estate. The way it works is you have a piece of real estate. You own that. Your name is on the title. The title is called the deed. You also, probably when you bought the house or when you took out a reverse mortgage or you took out a HELOC, whatever it might be, you signed a loan agreement. You got money from the bank and in exchange signed an agreement to pay them back in any number of different ways. Like, HELOCs can have different terms. Reverse mortgages don't have payments now, but have to be paid later. Conventional mortgages have monthly payments. Okay. So that's what that is. Now, what a mortgage is then is a security interest in the house. It attaches the loan, the debt, to the house itself and allows for non-payment purposes the bank to force a sale of the house through what's called a foreclosure proceeding so they can get repaid their money. Now, the best way to illustrate this is, let's say that you have a house worth $500,000. You own it and you have a debt of $250,000 and you lose your job or something happens, you get injured and you can't work or you don't have enough money or you just say stop paying the mortgage. What's going to happen? The bank's going to say you're in default of the loan. You owe me money. Okay, I have this right under this mortgage to foreclose on your house, and I'm going to follow all those terms, and I'm going to do that. Okay? They force a sale of your house. Now, the house is sold for $500,000. Where does that money go? Does the bank get $500,000? No, because they're only owed the loan agreement you had, which was $250,000 plus interest and penalties and whatnot. Let's just keep it simple and say it's $250,000. So they get $250,000, and the remaining equity in the house goes to you because it's yours. So you have equity in your house, I would hope. I haven't really seen many people with houses underwater these days. I know we saw this a lot in 2008, and maybe this is you. I don't know. But most people are not underwater in their houses these days. They may have a loan for 50%, for 25%, for 75%. Either way, there's equity there, and you need to plan for what happens with that house and what happens with that equity. Courtney, I think we have time for one more. And if anybody else has any questions after this one that Courtney's going to read off, go ahead, email us, call us, set up that discovery call. We are here to help you.
The final question is, when your children have spouses, do you name only your child, or are you required to name their spouses as well?
So you are not required to name their spouses. Your estate plan, you aren't required to name anybody in your estate plan. Okay. Now, people may have rights to contest or rights to claim things, but a different story. The spouses of your children don't have any rights whatsoever. Okay. And you aren't required to name anybody. It's your estate plan. You can do whatever you want with it. Okay.
Okay, perfect. Again, if you have any additional questions, I know there was a couple we didn't get to, you can schedule a call and we're happy to address those as well. And if there's any topics, whether it's Medicaid, nursing home Medicaid community, we have a ton of previous webinars and we're looking forward to doing more as well. So we have a ton of information and we're happy to help. Our phone number is available there, our email, and you can, of course, use the link to schedule directly.
And if you could help me and Courtney out with improving our webinars or topics or what topics you want to hear, check out in your emails for a feedback questionnaire. It means so much to me to get feedback on where we can get other topics out to you and where we can improve. And so I would love that if you could help me out. Thank you.
Thank you so much for joining us. Have a great rest of your day.